Back to the Dean Obeidallah Show. Joining us now, it is our friend Glenn Kirschner, former 30-year federal prosecutor, serving the U.S. Army in the JAG Corps. YouTube channel is Justice Matters with Glenn Kirschner. His Substack, you got to sign up for it every night at 9 p.m. He does a day in review about the laws cases. So check that out on Substack. Glenn, nice to see you. Thanks so much for being on. And I do sincerely enjoy your Substack.
No, and I appreciate yours as well, and I always appreciate jumping on with you.
Thank you. But so let's talk about, while there are times we're on and the law cases are the headline cases, this is different. They're a little below the radar, but they're all cases that are important and deeply concerning, frankly. One is, and you just talked about it recently on your Substack, it may have been last night, in fact, the Supreme Court making it easier on Monday for the Trump administration to deport people to third countries that they have no connection to, even ones which are deadly and unstable, like South Sudan, where they're in the middle of civil strife and there's humanitarian crisis. Like, we're just pushing them out of a plane and going, good luck with life. I don't understand how, as America, forget the law for a second, as the United States of America, how can we be doing this?
Yeah, so the justice gods, giveth and the justice gods taketh away, because we have talked about how the last three cases on the due process front, actually the Supreme Court ruled in favor of due process. One vote was even 9-0, unanimous in favor of due process. That was the first Abrego Garcia case. And then the next two cases were 7-2 in favor of due process. Well, now they took some due process away. And here's the thing that is maddening, Dean. I read the opinion. It's a 19-page opinion, all of which is the dissent from Sotomayor, as joined by Kagan and Ketanji Brown Jackson, and zero rationale, reasoning, or legal support for the six-justice majority saying, you know what, due process, schmoo process, when they want to deport people to third countries, third country removals, where those people might be at risk of torture, persecution, and death. Dean, call me crazy. It seems to me that that might be when due process is at its zenith, when it's really important, not just whether you are deportable, because in these kind of cases where we are now arguing over where somebody should be sent when they're deported, these are people who have often had their due process rights of notice and opportunity on the question of whether they should be deported. But this is like due process plus. There's a little due process twist. If you make an allegation that you have a credible fear of being deported to a particular country, guess what? Your due process rights are not at an end. You get a credible fear hearing and determination. Why in the hell the six-justice majority would choose to draw the line there on the due process front in violation, I think, of well-established legal principles, I have no flipping idea. I have no answer for it, other than that six-justice majority was just sick and tired of giving these immigrants all of their due process rights.
And, I covered this a few weeks ago on this show about what Trump regime was doing and can this rise to crimes against humanity at one point. And I was pointing out one of this bucket of people they're deporting to Panama, even though they have no connection to Panama, to South Sudan, even though they know, obviously El Salvador, they put them in a prison death camp. But like in Panama, they were sent to Panama. Then the people, because their home countries wouldn't take them. And a few times they didn't want to go to their home countries. And then Panama was putting them like in places in the jungle. And then it caused an outrage. They go, okay, that's not good, including children. And they brought them back. And I'm like, what are we doing? We have enough prisons. Why should we send them? We're sentencing them to almost to death in some third world country. You can just keep them in some prison here until you can figure out something better. You're forcing them to a country that they don't want to be in, and that it's not safe country. It flies in the face of everything that I believe this country should be about. That's what's so stunning.
Yeah, no, I can't begin to explain why the Supreme Court would die on a due process hill involving the potential torture and death of people who we take into our custody and send somewhere where they might be tortured or killed. Dean, first of all, let me back up, because I am not saying, and I would never say as a career prosecutor or as an American, all deportations are bad. No, people come to this country illegally. They commit all kinds of crimes, whether it's violent crime, whether it's sexual crime, firearms crimes, drug crimes, and they are convicted of crimes. They serve prison terms. And then the ordinary course of business, I know because I was in this business, is they are deported after they have served their sentence. That's very different from people who just come here undocumented and are working and paying taxes and abiding by the laws of our country. Two very different categories of people. But I would never say all deportations are bad. No, it's part and parcel of some of the important law enforcement functions of a civilized society to deport people who need to be deported, provided we're following our own damn rules, laws, and constitution. So, why this is where the Supreme Court chose to draw the line, I can't say, because they didn't say. What I found very persuasive was Justice Sotomayor's dissent when she said, you know what, in matters of life and death, we should perhaps be a little bit more careful when we're making decisions like this.
I agree. And I'm talking with a friend, Glenn Kirschner. So, Glenn, another case, you've covered a great deal, Abrego Garcia. I'm a lawyer. I don't know what is going on right now. So a federal judge said on Sunday that Garcia should be freed from criminal custody as he awaits the smuggling charges because he's back in the United States, in case people missed that in the media. There's so much going on in the world. He was brought back by the U.S. But then the judge was saying, well, he might not actually get released in the real world because some other immigration things. Today, the Trump administration made some other motion on this case. I'm at a loss for what is going on because it's two intersecting. Is it two intersecting things going on? There's an immigration bucket, and then there's a criminal justice, just normal, straightforward criminal justice prosecution lane. Yeah, two different lanes going on.
Let me unravel this and translate it from legalese to English. What I didn't know, Dean, is that there's some new court filing by DOJ. I'm not privy to that. I'm not up on it.
So, it's a bizarre thing. It makes no sense.
Let me talk about where we are and try to make it understandable. So, as we all know, the federal judge in Maryland, Judge Sines, ordered the Trump administration to facilitate the release and return of Abrego Garcia. That was affirmed by the Supreme Court. And then what the Trump administration did, they said, well, we'll bring him back, but not because you told us to bring him back. We're going to bring him back because we're going to gin up a Mickey Mouse indictment and claim that we now need to bring him back to prosecute him. Dean, the minute that indictment became public, I looked at it as a 30-year federal prosecutor. I said, this thing will fall apart because it's bull. It's garbage, right? And sure enough, what happened? Goes into his detention hearing in the Middle District of Tennessee, the federal jurisdiction where the case is brought. And the judge basically says, what is this garbage in this indictment that you've ginned up to try to convince me to detain Abrego Garcia in his criminal case? The judge was just wonderful in taking down this indictment. She said, first of all, you're relying on things like double and triple hearsay. And worse, some of the people that you're offering evidence through are not just cooperating witnesses, but guys who've been deported 5 times, guys who are serving 30-month sentences for some horrific alien smuggling crimes they committed and were convicted of. And you promised them, you spring them from prison. And you said, by the way, even though you've come here illegally 5 times and have been deported 5 times, we're going to help you out on that 6th go round. Now, Dean, do you think these people are going to tell prosecutors anything they want to hear about what a terrible person Abrego Garcia is? For gosh sakes, they just gave him the keys to his jail cell. And the judge concluded by saying, the evidence or information you are offering me is, it defies common sense. Federal court judges don't often tell prosecutors that their cases defy common sense. And the judge refused to detain Abrego Garcia. But there's a parallel case because he's also involved in a deportation case, which is separate and apart from this ginned up criminal prosecution. So what they said, the prosecutors, well, hey, judge, we don't really care what you do on this detention matter because we're going to detain him anyway in his deportation case, to which the judge said, I don't care. That's not my concern. I saw the judicial wood in front of me, and I am telling you, you don't have enough to detain him in the criminal case. Now go away, right? So that case hasn't completely fallen apart yet. It fell apart on the detention front. I predict it will fall apart entirely, and then he'll be left with a deportation case. And here's the thing, Dean. I know I'm going on a long time, but now in the deportation case, the issue will become, should he be detained pending further deportation proceedings, or should he be released back into the community? Here's my argument as the defense attorney. Judge, before the Trump administration kidnapped him, stuffed him on a plane to El Salvador, where a prior immigration judge had ordered the Trump administration he could not be sent to, and they sent him there anyway and stuck him in a prison. Before all of that, what was his status? He was in the community, working, supporting his family. You should restore him back to that status so you don't reward the Trump administration for acting lawlessly and unconstitutionally against him. Are you kidding me? That, I think, is a compelling argument.
Is it a different standard between a federal court criminal prosecution and an immigration court in terms of holding someone in custody until their hearing dates?
So let me be upfront. I have never been an immigration law practitioner. So
Okay.
I'm going to give you my best take on that based on my career as a federal criminal prosecutor, not immigration.
Sure.
Ordinarily, when we move for detention of somebody pending trial, we have to prove either by a preponderance of the evidence, which is 51%, or clear and convincing evidence, depending on the exact basis that we're seeking detention on, whether it's flight risk, whether it's a risk of obstruction by intimidating witnesses, whether it's a risk of danger to the community. Those are the evidentiary standards we have to prove to the court's satisfaction, either by preponderance of the evidence or clear and convincing evidence there are flight risk or a danger to the community. I'm not sure of the precise burdens and showings required in the setting of a deportation matter, but I would think it is largely kind of a similar burden of
Sure.
proof, but I can't swear to it. You know, that's my best take.
And look at, like, to shift gears in a second, but stay in this world. Mahmud Khalil, the grad student at Columbia, was detained for months. Other people who were arrested for the same thing after him were released by judges because there was no priors, there's no crimes. It was about him expressing political opinions that this regime didn't approve of. That's all it was. They were political prisoners. And then they came up with a new charge to try, not Khalil, not like in this with a crime. They're saying he didn't say he had a job years ago at the UN Relief Works Agency. And the judge kept him for a few more weeks. And then ultimately the judge goes, I don't know why we're keeping him. There was no reason to keep him. That didn't make him a threat to anyone. And it's absolute bullshit. Until the Trump regime, we had a great relationship with the UN Relief Works Agency. We funded it. And then the Trump regime says they're bad now, so we don't do anything work. And you didn't tell us you worked for them, so we would have never given you a green card. They would have given them a green card before because it was never an issue. Trump, with Netanyahu, made it an issue, this new thing. So I thought that was remarkable. That I'm glad he's out. I'm glad the political prisoners are out.
Yeah, Dean, this is Pam Bondi's Department of Justice sending these third-rate lawyers from the Department of Justice into court on what I view as legal suicide missions, figuratively speaking. They are insisting that these attorneys go in and, at its core, argue that everything Donald Trump does that's lawless is actually lawful. Everything Donald Trump does that is unconstitutional is actually constitutional. I swear it reminds me of George Orwell's Ministry of Truth, because the Ministry of Truth was the government agency that was responsible for writing and disseminating propaganda to the people. That's where we are. That is why they're losing in court every damn day. It's not because the judges are lunatics or deranged, as Donald Trump and Pam Bondi claim. It's because Donald Trump and his administration is doing so much illegal and unconstitutional stuff that the courts are simply developing the facts, applying the law, and ruling against the Trump administration. And, I hope the courts continue to hold, because I'm sure we're going to talk about how now, in their next layer of attack, welcome to today's episode of Donald Trump's sprint toward autocracy. Now, the Department of Justice is suing all of the federal judges in the district court in Maryland. I mean, this is a special kind of insanity.
This is not making national headlines, although it should, because according to reporting, and I was going to ask you, because I'm like, I haven't heard of this. And I looked at the complaint. It's the United States of America versus all of these judges by name. Now, you've got it. Now, it's in their capacity as judges. But as the reporting is, the Department of Justice filed an unprecedented lawsuit against all of Maryland's active federal judges because you're upset with a ruling on standing and about slowing down their deportations. So they're suing the judges individually. And Steve Vladeck, the professor at Georgetown Law, said, we're seeing an unprecedented attempt by the federal government to portray district judges not as a coordinate branch of government, but as nothing more as a political opposition, and is to undermine our judiciary. So can you share, because this is stunning, and I don't think the media is picking up on it because it doesn't make sense to anyone. No one knows what's going on.
Yeah, I don't think there's any precedent for a Department of Justice to sue all federal district judges in a given jurisdiction because they don't like a rule that
Right.
federal jurisdiction set. First of all, what's the rule they set? They said anybody who files for habeas relief, in other words, they're about to be deported by the Trump administration unlawfully in violation of their rights to notice an opportunity to be heard before they're deported. Anybody who files that kind of a petition with the court, we're going to put a 2-day hold on it. Why? Because the Trump administration has chronically and perpetually been violating people's due process rights before we can even get to the writ that they filed, trying to exercise their right to notice an opportunity to be heard. So there's a 2-day automatic injunction. And so they said that so frustrates the government's ability to run the executive branch, to run foreign policy and domestic law enforcement, that they sued all of the judges to try to get them to revoke that 2-day preliminary injunction rule. So I have a couple of observations about it. First of all, and I always have to call it the way I see it, I think it's not only very forward-leaning for the federal court in Maryland to do this, and I think they were trying to address an obvious improper, unlawful, unconstitutional act and acts by the Trump administration. But on the other hand, typically judges can't just say, listen, I'm going to grant preliminary injunctions in all cases for 2 days sight unseen. That does run contrary to how preliminary injunctions are usually issued by federal judges. So there's something to talk about here, but there's so much to dislike in this, because here's what it boils down to, man. I wish we had an hour. We could do a whole, law school class on this. The federal government is becoming what I would call a vexatious litigant. What is that? It's somebody who so abuses the court system, and they're not acting in good faith or with clean hands, that the courts say, you are a vexatious litigant. In other words, you so persistently abuse the court system that we have to put special rules in place for you. And there may come a time where we deny you access to the courts altogether if you are sufficiently vexatious. Loosely translated, that means pain in the ass, right? Usually these are people who are filing frivolous motion after frivolous motion day after day because they're locked up and they have nothing better to do. And the courts can designate them a vexatious litigant and cut off access to the courts. That, I think, is where we are headed, because Donald Trump's executive branch is defying court orders over and over and over again. And they're trying to find cute ways to work around the due process rights of notice and opportunity to be heard. And that's why this district in Maryland put this rule in place. Listen, we need a dang 2-day pause so you don't just snatch people up before they have a chance to have their constitutional rights honored.
And look at it this way, the Trump administration, a 2-day delay doesn't affect anyone. They're in custody. There's no risk to anyone. Most of the people they're picking up now, as we've learned, don't have criminal records whatsoever. I had on last week an expert who said they're looking at the data and it might only be about 10% of the people they've deported have a criminal record. They literally just taking moms and dads and sisters and brothers who have been working here, part of the community, because they're easy pickings. They go to restaurants, they go to Home Depots like from decades ago. So it is remarkable that for a 2-day, it's too much for them, 2 days, because Tom Homan, the border czar, has got to hit some quota to get his, I guess, a watch. Maybe it's a gold watch or a free pizza. I don't know what he's going to get, but it's bullshit. And this is what we're dealing with. And Glenn, the last case I want to touch on in the last few minutes here is something that you talked about, and I was going to write about it. And you summed it up so well. And that's the National Guard case in California, where the district court judge did a great opinion. And I went through, we may have even talked about it, Judge Breyer. And then this appellate court, 3 judges, 2 Trump appointees, but a Democratic appointee, are analyzing Trump and what he's doing like he's a normal person. They're applying old standard to a man who attempted a coup and incited a terrorist attack on our Capitol, who's convicted of 34 felonies for cheating in the 2016 election, who wants to be a king. And I know that seems weird. We're lawyers. You can't go like, throw everything out, just apply new rules to this guy. But you say they're ignoring reality, and I could not agree with that more, and it's very dangerous. So share a little bit, please, your point of view on this.
So Dean, there is this rule in the practice of law. It's called the presumption of regularity. So when the federal government does something, when a president of the United States does something, we presume regularity. We presume it's lawful. We presume it's constitutional. That, I think, has served us well as a starting point for litigation. But when you have an abjectly criminal president who literally is sitting in the Oval Office day after day, issuing unconstitutional executive orders with, Reagan-appointed judges saying, these are blatantly unconstitutional. Where were the lawyers in the room? Well, the lawyers were in the room, but, they were probably Project 2025 lawyers. You can't apply the presumption of regularity to a criminally irregular president. So that's why when you have that extraordinarily thoughtful opinion that says the law provides that there has to be an invasion or a rebellion, or the executive branch, the president and his law enforcement agencies, are unable to execute the laws of the United States, or you can't take over a state national guard. Those things aren't present. The appeals court said, yeah, but there's like a presumption of regularity. So in other words, Dean, even if there's not one flippant iota of evidence that we're engaged in an invasion, that we're suffering an invasion of a foreign country, a foreign military force, if Donald Trump says, I see an invasion, presumption of regularity, you can't go around that. You can't look behind it. You can't even require any proof of what he is saying. That's insanity. I think even with a law-abiding president and administration, that's insanity. And certainly with a criminal administration, it is a recipe for the end of our republic. The courts have to wise up. Most of them are. Most of them are holding strong. But this Ninth Circuit Court of Appeals opinion in California is bonkers.
Do you think, look, there are district court judges who have been doing the right thing, including Republican appointees all over. Do you think, and this might be too simplistic or maybe not, district court judges deal with litigants. They deal with real people in the real world every single day. They're trying cases. The appellate judges don't see real people. They see briefs and lawyers, and they talk about it like it's a law school class. And I wonder if that plays a role in why district court judges are seeing things bluntly for what, because Breyer's opinion, talking about a king versus a president, he gets what's going on. And these appellate judges, including the one that's a Democrat, are like, well, 1876 and like, what are you doing? You're citing cases with a madman there. Do you think that's part of it?
I do. I mean, listen, we always talk. Listen, I have enormous respect for the federal circuit court judges around the country. But, often we say they're sitting up in their ivory tower. They're dealing with issues of law. They're generally not dealing with issues of fact. Facts are developed in the trial court by the trial court judge during adversarial litigation. And then that record is cemented, that factual record, and the trial court judge makes legal rulings based on that factual record. The appeals court, once it's sent up to the appellate court, they're not dealing with the facts. They're dealing with exclusively the law, and yes, how the law should be applied to the facts as found by the trial court. But yeah, they're a little bit removed. They're not involved in facts. They're more involved in law. And the other thing we need to remember is their ruling only had to do with the preliminary injunction piece, whether Donald Trump has to relinquish authority back to Gavin Newsom of the National Guard right now, not ultimately getting to the underlying legal issue that has to be resolved and that's still being litigated through the court. So it was a very narrow ruling, but a dramatic ruling, because what you're doing in the real world, Dean, is Donald Trump is creating chaos and confusion. And then he says, wait a minute, look at all the chaos and confusion. I've got to send the military in to tamp it down. And common sense dictates that, sport, you're the cause of the chaos and confusion.
Yeah.
You can't then use that as an excuse, as a pretext to send the military out and turn it against the citizenry, because that's kind of common sense. And that's what I think the appeals court maybe loses sight of.
I agree with you, and I think that's part of it. It's living in the real world or living in the ivory tower world. Well, Glenn, I want to thank you for breaking down all these cases for us. Justice Matters with Glenn Kirschner. It's the YouTube channel, over 1 million subscribers now. And the Substack, is it still also called Justice Matters, or is it?
I think it's just under my name, Substack, GlennKirschner.com or whatever it is. I'm not
sign up for Glenn Kirschner, because you'll see videos every night making sense of the law. Thank you, my friend. Have a great day.